Hello, and welcome to today's webinar on the difference between DRBs and DABs, brought to you today by the CIArb Egypt branch and the Dispute Resolution Board Foundation. I'm Ann Russo, Executive Director of the Dispute Resolution Board Foundation, or DRBF, and I'm joined today by two very experienced and knowledgeable folks who are experienced in both the DRB side and the DAB side. So today we have Elizabeth Tippin. She is president of the DRBF's Region 1 Board of Directors, and she's based in California, USA. And we also have Dr. Ahmed Wali. He is an associate professor and a fellow with CIArb in the Egypt branch, and he's joining us today from Cairo. So welcome to you both. Pleasure to have you here with us. And I'm going to start today's session by raising a question for our attendees. So I'm going to pop a poll up onto your screen. And if you could take the opportunity to please respond to the poll, we'll leave it open just a few moments. And this will allow you the opportunity to let our speakers know what the experience is of our attendees. So we'll just give that a moment. All right, more than half have responded so far. All right, so it looks like we're trending with the majority having no experience on being on a project with the dispute board. Now, this could be both the scenario of having being a project engineer or representative on a project that is utilizing a dispute board for its dispute resolution, or it could be serving as a dispute board practitioner, a member of that board. So I'm going to go ahead and end the polling, but to give you the results, we have 29% have had experience on a project with the dispute board and 71% have not. So that's where we stand at the moment for today's session. Keeping that in mind, I'd like to kick us off here with a first question to Elizabeth. Can you talk to us about the basic definition of a dispute board, and then what the difference is between a DRB, dispute review board, and a DAB, a dispute adjudication board?
Good morning, Ann. Thank you. And it's a pleasure to be here speaking to everybody today. You know, both a DRB and a DAB have the basic same premise, which is the premise that a dispute board is typically a 3-member panel or board that is selected by the owner, which is often in European countries called the employer, and the contractor at the beginning of the construction of a project. The 3 people are respected professionals. They can be architects, engineers, builders, contractors, attorneys that are specialized in the type of construction for that particular project. So their role is to meet regularly at the project. They start at the beginning of the project and they meet monthly or quarterly, whatever the parties agree to. They review the project documents and they actually conduct a site visit so that they can see the progress of construction as the project progresses. So if the project is going to take a year, there might be quarterly meetings or monthly meetings. If it's going to take 5 years, then the panel would meet at the project site. They would meet with the owner's representative and the contractor's representative. They participate in avoiding disputes by really having a proactive meeting where they talk about the issues. They talk about the construction management, about the request for information, the RFIs, the submittal log. They look at kind of the status of the progress of construction, and they ask probative questions to try to elicit information from the owner's rep, the contractor's rep. And at the next meeting, if an issue comes up, you know, they ask, what's the progress on that issue? So what happens is the avoiding of disputes really happens through increased communication between the parties. They also resolve disputes while the project is being built by issuing recommendations and opinions. And that's where the difference really comes in. The process is outlined in the contract, or if it refers to rules such as the ICC rules for a dispute board or FIDIG rules for a dispute board. The dispute review board, which is typically used in the United States, those recommendations are advisory. They're not immediately binding on the parties. The contract usually outlines how long the parties have to accept or reject the opinion or recommendation, the advisory opinion that the DRB comes up with. Typically it's 30 days or maybe 28 days or 15 days. Anyway, whatever it is outlined in the contract, the parties have that time to accept or reject that opinion. If they don't say anything, then it becomes a binding opinion. If they do object to it, then it really gives the parties an opportunity to continue negotiations. And if they can't resolve it, and I will say that in the United States, 95% of all of the issues that get an opinion go through the negotiation and get resolved. They have the opinion of this 3 people who've been on the project all the time, and that's influential for them. The difference between a dispute adjudication board is they actually issue decisions that become immediately binding on the parties, but they can issue a notice of dissatisfaction, either party, within a certain time limit. And if they do issue a notice of dissatisfaction with the DAB decision, then they could submit it to arbitration or litigation, depending upon what the contract provides. So they're both very similar. Difference is in the formal hearing, how it's labeled, how it's addressed. And I would say that both of them are consistent in that they can, you know, during the process of the project, they can give the parties informal opinions or recommendations if requested. So they really go towards making the project come in on budget, on time, with no residual disputes. And that's about it. Thank you.
All right, very good. Thank you, Elizabeth.
Sure.
So I know a lot of our attendees work within the context of the FIDIC contracts. So Dr. Ahmed, I'd like to ask you, with the FIDIC contract style, the contracting parties empower the DAB to decide on their own jurisdiction and the scope of any dispute that's put before them. So what does that mean exactly? And how can that power be abused by dispute boards?
Okay, thank you, Anne. It's a pleasure to be here with you today. And as you said, the FIDIC give the parties, give the dispute boards the power to decide on their own jurisdictions, which means, just to put it in simple words, which means that any dispute that will be referred to the panels, they have the power to decide if this dispute is within their own, they have the right to make a decision, or they can say that it is out of our scope of work. From my experience, I don't think that it is not a major issue. This is usually an issue in arbitration, because in arbitration, some parties or the disputants may refer some disputes that are outside of the scope of the arbitrators, or based on how the arbitration clause is drafted. But in adjudication, it's a little bit different, especially in a standing arbitration. You know, we have a standing dispute board. In a standing dispute board, you are starting from the beginning of the project. The dispute board is formed at the beginning of the project. So normally all the disputes that will arise throughout the execution of the project will be within the jurisdiction of the dispute board. The problem will arise if you have an ad hoc dispute board, because in an ad hoc dispute board, sometimes the parties will, it will be like an arbitration compromise. They will decide on what issues should be referred to the dispute board. And in this case, the board should be very careful and to ensure that all the disputes referred to them are actually within their mandate or their dispute board agreement with the parties. From my experience, I've never had a problem with that. But I believe that in an ad hoc dispute board, this may cause some problems.
Very good, thank you. So, Elizabeth, how does that compare to practice in the United States? Is there similar issues of the DRB that FIDIC has for DAB contracts to decide on their own jurisdiction?
No, in the United States, of course, one party can bring a dispute to the dispute board. So, one party brings a dispute to the dispute board. If the other party disagrees, the dispute board does not have jurisdiction to hear this issue, then the dispute board is going to really look at the contract. The contract sets out the scope of work that the dispute board has. So if the contract language defines that sometimes the contract says that the dispute board can decide its own jurisdiction on an issue. Sometimes you have a situation where, say the contract says that all issues must be submitted to the dispute board within 30 days of the finalization of the construction. And if it's within that 30-day time period, one party will say you don't have jurisdiction to hear that issue. And if they look at the contract and it says we don't have jurisdiction, then they might say, sorry, we can't help you, unless there's an agreement by both parties to let the dispute board hear the issue. And the issue comes in, again, Ahmed's talking about standing versus ad hoc. Standing from the beginning of the project, the dispute board regularly meets with the parties, builds that trust so that the dispute board knows that they're familiar with the issues, knows that they can be neutral, can be trusted. That trust is developed. If it's an ad hoc situation where the parties don't really have a relationship with the dispute board, it's a neutral relationship, but nevertheless, it is a relationship. If they don't have that, then there's probably more of a fine line between, getting an agreement from the parties to have the dispute board hear the issue. So, it's a similar situation. I think sometimes I'm familiar with, the American Arbitration Association has dispute board rules. And I recently was talking with a dispute board member about a project that they had that referred to the AAA dispute board rules. So that became, wrapped into the contract. But most of the time, the contracts in the United States for the clauses regarding dispute boards do not refer to any rules. It doesn't refer to ICC. It doesn't refer to FIDIC. It doesn't refer to the foundation, which doesn't really have rules of process rules, recommendations, but not process rules. So it's pretty much what is in the contract in the United States. And the jurisdictional issue is one of those. If the dispute board decides to go ahead and hear the issue, and they do, and if one side doesn't like it afterwards, they can have it thrown out because they didn't have jurisdiction if they don't. So
Right.
it can become an issue of enforcement.
Yes. All right. Very good. Thank you. Well, I'm pleased that you brought up the issue of rules. I understand that the Cairo Regional Center for International Commercial Arbitration has been working on some local rules. So Dr. Ahmed, can you give us some information about how that project is progressing and when those are expected to be published?
Yes, sure. And actually, I was privileged that I prepared the first draft of these rules. I started 2 years ago, and then I was also in the committee, a committee from eminent professionals from all over the world who reviewed the first draft and made the final draft, which will be available hopefully next month by January 2021. That's and I think it will be the good thing about these rules that it is combined. It is not, as you said, in Egypt, we are mainly using, or the Middle East, we are mainly using the FIDIC contract. So people are more familiar with the DAB concept. But these rules will be for dispute boards, for both types of dispute boards. So they are covering the dispute adjudication boards and the dispute review boards. They can be used in both situations. The Cairo Regional Center will announce, I think, a big event during the first quarter of 2021 for the inauguration of, or the announcement of the new rules.
Great. That's great news. And I'm pleased to hear that the rules will cover more than one style. You know, the DAB is obviously gets a lot of attention, but to understand the other versions of dispute boards, I think would be very useful, because there's some very strong lessons that we can learn from the different applications. So Elizabeth mentioned the DRBF does not have rules per se, but we do have recommended best practices. And so I'm just going to let you know, we do have a manual that is available for free download from the DRBF website. This covers DRBs, DABs, and a number of other types that may be useful for attendees. So I'm going to pop that in the chat so that if anyone is interested in downloading a copy, you're welcome to do so and get a little deeper dive there. But moving on from our rules and best practices, Dr. Ahmed, I'd like to tee up a question for you. We hear that some employers may resist the concept of a DAB because of it forcing a decision onto the parties. And frequently the contractor is the one who refers a case to the DAB. So is it expected that in a DAB setting, employers would always object to the decisions by the DAB? Has that been your experience?
Okay, actually, you said at the beginning, some of the employers. I would say most of the employers, not some of the employers. And yes, from my experience, first the employer is the one who will draft the contract. Most of the employers will require the drafter, whether it's their consultant, lawyer, engineer, or whoever, to delete or omit the dispute adjudication board from the contract conditions for two reasons. The first one, you said it, which is they do not want a fair or an independent panel to give them a binding decision. And the second reason is that, unfortunately, some employers believe that it's extra money that they will have to pay during the project, and that they don't need to pay that money, okay? And then, however, if we have a dispute board, and as you said, that many times, or not many times, in whenever the decision is for the contractor or against the employer, then maybe in 99% of the cases, the party whose decision is against him will send a notice of dissatisfaction. He just don't want the decision to be final because, as you know, if he doesn't serve a notice of dissatisfaction, yes, it will be binding, but it will not be final. So usually he will send a notice of dissatisfaction so he can take the dispute later to arbitration or litigation, as the case may be.
Very good. All right. So how can we compare that to, Elizabeth, your experience in the US? What is the employer or project owner's attitude about the process?
Well, typically the owner, and we don't say owner, we don't say employer in the United States per se. So when I say owner, I mean employer. But typically the owners are in control of writing the contracts. They write the contracts. Sometimes they don't like dispute boards. They like another process. They're being written by attorneys for owners and they want their day in court. So a lot of times they select arbitration as being, mediation and arbitration are very popular in contracts, or just going directly to arbitration. And sometimes litigation. I know I've seen some P3 projects where you have multiple layers of parties involved, and each layer will have a different type of dispute resolution methodology. There'll be a dispute board on one layer, arbitration in another layer, mediation, arbitration, and then litigation. And it's one project with all different kinds of methodologies. So owners are in control. And, you know, if they have made the commitment to using a dispute board, they put it in their contract. I would say that contractors don't really write contracts for projects. It's the owners who are really developing those contracts, unless it's a really small, like residential project or something. But for large infrastructure projects, they're all being written by the owners. So because they're advisory and non-binding, typically in the United States, the attorneys that are writing these policies and the contracts look at it as a potential help to save money on the project rather than an expense. So the help to save money is that at the end of the project, there's not going to be all these residual claims that are going to increase project costs and increase litigation costs. The issues can primarily be resolved while the project is ongoing. I do want to say that one project that I've been working on as a dispute board has a contract term that says all issues from up to $1 million are binding. The decision by the dispute board is binding, and anything above $1 million is advisory. So they wanted to get, you know, certain dollar amount issues resolved, and beyond that, it would be advisory so that they could continue with, in that particular case, an arbitration process. But, you know, I would say that, you know, owners are very agreeable to having dispute boards, and not all owners. You know, certainly there's a lot of work to be done in the United States, Canada, and the Caribbean islands, Region 1, to encourage the use of dispute boards. But generally, it's being used by all different types of projects, you know, across the board. Owners are in control and contractors like them too.
Yeah, I think that's true. I've heard also of contractors revising their bids based on whether there's a DRB in place, because they know that it's going to have a significant impact on the claims process, and they're very agreeable to that. So I think that both party members have a lot of importance in the acceptance of DRBs in the US. They equally see the benefit of it. And I also hear that often some of our strongest advocates are ones who have had very bad problems in the past. They've been burned so badly with high litigation costs and projects that run on way too long. And they are some of our most devout advocates for this new way. You know, they consider it a new way of working to avoid the repetition of that. One of the state users in the US had a very large legal department until they started using DRBs, and now they just have, you know, one person who manages the program. So, so there certainly are some good examples of that within the US where they feel amenable to it because they do feel like they still have some control over continuing negotiations and finding the resolution that they need.
You know, I'm going to add one thing, and thank you. Caltrans, the California Department of Transportation, keeps statistics about their projects, and they mandate that a dispute board is pretty much on every project that they do. And their statistics show that the dispute board probably 50% of the time when they issue a formal decision or a formal recommendation, 50% of the time it's for the owner, and about 50% of the time it's for the contractor. So, you know, the issue again is, you know, this trust element. If it's for the owner, is the contractor going to agree to it or not? You know, if the decision is for the contractor, is the owner going to agree to it or not? You know, those issues are kind of bore out by the statistics showing that it is a pretty even distribution of decisions for one or the other. And it's really, again, the parties' trust in the people that are on the dispute board, their backgrounds, their involvement, their conversations, their knowledge as to whether they're going to feel like I'm going to accept this or not.
Yeah, that's a great point. I'd just like to mention, I've put it in the chat, but we are going to have some open questions at the end. Some of these that we're reviewing today have been presented in advance. But those of you who are watching live, if you'd like to pop a question into the Q&A for the panelists to address, we are happy to field those. It looks like a couple of people may have raised their hands, but I would just ask if you could put your question in the chat, then or in the Q&A rather, then we can make sure that we don't miss any opportunities today. So having said all of that, I want to back it up a bit here and ask both of you to talk a little bit about the other forms of dispute boards. You mentioned discussing it in the local rules, and of course the DRBF's manual covers a variety of different types of dispute boards. Anything from a 1-person to a 3-person, and even a combined dispute board or a larger panel. So I'll maybe start with you, Dr. Ahmed. Can you comment on any that you have experienced or ones that you think are particularly of interest within your local area?
Actually, all my experience is with dispute adjudication boards, whether one that is formed of one member or 3 members. The variation was between standing and an ad hoc panels. Even when ad hoc dispute boards, the contract included a standing dispute board clause. However, parties agreed not to make effect of this clause until a dispute arises. And that's typical in projects in Egypt, unfortunately. People doesn't know the importance of having the dispute board early at the process. Participants need to understand that a dispute doesn't start in a day. It starts as a risk that is not clearly assigned in the contract, and then it will transfer to a conflict that is not adequately managed, and then a claim that is not properly resolved, and then it will become a dispute. So having the dispute board early at the process will definitely eliminate this no effect, and it will avoid the dispute as early as possible. Other forms, yeah.
Before you move on, can I just ask, I hear quite a bit about this question of when it's appropriate to use a single person DAB versus a 3-person DAB. And I think for people that are not experienced with the process, they tend to immediately default to this idea that, oh, well, 1 person costs less than 3 people, so I'm going to start there. But of course, we know from long-term experience that sometimes that ends up not creating the ideal scenario. So what's happening within your area with regards to that? Is that the default thinking, or is it defined based on the type of project, the size of the project, other factors that come into play in that decision making?
Okay, definitely it has to be decided based on how complex the project is. So the more complex the project, and you have a lot of technicalities, and so in this case you will need 3 board members so they can deliberate and discuss these technical issues. However, normally it will depend on the size of the project. People, when they have a small project, although again a small project in Egypt, normally they don't include a dispute board clause. However, when the project is I would say less than $50 million, they will not, they will normally go for a 1 member. If it is more than that, then they will probably go for 3 members.
Yeah. I think that's a great point, and it sounds common to other areas as well. And it actually brings to my mind, if you don't mind me going on a sidebar here, but the issue of board member selection. You know, you mentioned needing 3 people to handle a complex technical issue. And I think the point of that comment is that you really need 3 people that are all bringing something unique to the table, which makes the unit much more capable of handling the variety of things that could come up that are maybe unknown at the start of the project. So could you maybe touch briefly on board selection, board member selection? Yeah.
Okay. As you know, members are selected. If we have 3 board members, each party should select a member, and then both members will select the 3rd member, normally after taking the approval of the party. So it's a little bit different than arbitration in this regard. The selection, in the selection, there are some criteria that is written in the agreement, such as the experience needed, the language experience in the area, and so on. However, I would always advise the parties to select experts with different backgrounds related to the project. So if you have, for example, a water desalination plant, okay, then probably you need someone who is expert definitely in contracts, but also in mechanical engineering, okay? If you have a dam, then you need a civil engineer and an electromechanical engineer, and so on. So combining these different experience and background will definitely enrich the dispute board decision, and it will make it more proper.
Great point. Elizabeth, anything you'd like to add on that? I know he referenced the most common form where the employer and the contractor each select someone. And particularly in the US, there's been a movement towards selection, which is now the DRBF's recommended best practice. So could you comment a little bit on that and the effect that it has on creating this balanced board?
Sure. And I concur with everything that Ahmed has said. Basically, the joint selection process actually makes both parties, the owner and the contractor, bring together a list. Say each brings 8 people that they think they would like to have on the board. And then they actually get together, and I've been involved in interviewing processes where they actually set up a Zoom interview with prospective members. They interview them and they actually participate in a collaborative process to select the most appropriate 3 members. So this concept of requiring the parties to put some effort, it takes some effort to, these are the 8 people, takes some time to interview people. Interviewing isn't necessarily done, but getting the list down to getting a list of 16 people or 10 people down to 3 takes this collaborative process and really starts to invest the parties in trusting who's going to be selected. It's basically both parties have to agree, and I agree. I think that the skills of the people that are selected need to be complementary. If you have an engineer, experienced mechanical engineer experienced for the desalination plant is a great example. You have somebody who's familiar with construction techniques and somebody who's familiar with contract terms. You have a balanced board. And so developing, the parties actually developing a board in that manner really is a great step to resolving conflict on the project. I also wanted to say, the dispute advisor, which is one person, is used a lot in the United States. A number of agencies have developed their own specification, basically with the help of the foundation, frankly. And their specification allows that if a project is up to a certain dollar amount, they'll use a 1-person dispute advisor, versus beyond that, they use a 3-person dispute board. And, they do have some decision-making process regarding the complexity of the project, as Ahmed mentioned. If it's a complex project, even though it's small, they might want to have a 3-member dispute board on it. I just wanted to, the ICC has rules. FIDIG, of course, has rules for dispute adjudication board, dispute avoidance and adjudication board. The combined dispute board in the ICC rules allows for issuing recommendations. And if the parties agree, then they can issue a decision. So there's a lot of flexibility, and in the United States, everybody's writing contracts as they see fit. So with these agencies like the California Department of Transportation, they have their rules established, and they have a lot of construction projects. They have their rules established, they follow those rules. But for other projects such as an arena or a performing arts center or a hospital, they're developing their own contracts and really establishing their own rules about selection of DRB members and about the scope of work and the authority of the DRB members. We definitely have both standing and ad hoc here in the United States. There is a big educational push to get everybody to agree to a standing board, but that doesn't always happen. But I think it's becoming more common that, it's really important to select a board to get that avoidance of disputes process by having them start at the beginning of the project and meet regularly at the project. So,
it's kind of funny if you can get that avoidance component working well. The issue of whether it's a recommendation or a binding decision is moot because you don't actually have a formal dispute that needs resolution. You have sorted it out at the absolute lowest level and through more, conciliatory type relationship and It's funny that we'll sometimes say the very best dispute board is one that we have no statistics on, because everything was done in an advisory capacity and in an informal way. There were no formal hearings, no question of whether the decision was accepted by either party. Those are some of our shining stars.
Yeah, that's good.
We did have an interesting question come in that I wanted to ask you about. This idea of whether you could start with a DRB and then evolve to a DAB. So starting with the more informal recommendation style, but depending on how the project progresses, maybe moving towards that binding. Now, Elizabeth mentioned a contract that just delineated the binding and recommendation based on the size of the claim. But this is a question more about the time and how things progress over the course of the project. I see Dr. Ahmed nodding quite a bit, so perhaps you can tackle this question for us first.
Yeah, actually, Elizabeth sort of answered this question, that the dispute boards are flexible enough that if both parties agreed at the beginning that it will be a DRB, and then in the middle they agreed, and definitely the board also has to agree with this decision, that they because I cannot start at the DRB and then being compelled to transfer to the DAB. So parties and the board, if they all agree that we would like to make it a dispute adjudication board in a specific matter, or that from now on we want you to continue as a dispute adjudication board, then that's fine. As long as everyone is happy with that and the parties agreed, then I don't think there is any problem. And as Elizabeth said, sometimes it will be flexible, that based on the dispute referred, they will request you to issue a recommendation or a decision, or they will totally change the nature of the board from being a DRB to a DAB and continue forward.
Okay, so let's take that now a step further. The avoidance doesn't work, and the dispute continues to escalate up the ladder and decides to go to arbitration. So the question is, can a dispute board member become the arbitrator on the same dispute if the parties are mutually satisfied with their performance as a DB member? Elizabeth, would you like to answer that first? What's your experience?
You know, I wanted to just reiterate one particular word stood out that Ahmed used, which is flexible. This process is flexible, and if the parties agree that the DRB is going to make a final binding decision like an arbitrator, they may not change the wording for the dispute board, but it's a flexible process to allow the parties to have control even while the process is ongoing. At the beginning of a dispute, when the contract is being drafted, there are no disputes. Or at the beginning of a project, when the contract is being drafted, there are no disputes. And it's a lot of times easier to get parties to agree to a definition or contract terms about what the dispute board is going to do. You know, I'm on one project where the dispute board was not impaneled until the project had been going on for 3 years. At the time that the dispute board was brought on, the first meeting, there was over 100 issues, 100 disputes that the parties had. They never really got it together. The contract was terminated. You know, the dispute board wasn't really given authority to resolve those cases. But the parties agreed that the dispute board was going to act as the arbitrator after the project was terminated, basically. I mean, a new contractor is being interviewed at this point in time, that the dispute board actually was going to hear those disputes. So, and the parties, you know, wrote basically a written agreement to that effect. So they're expanding the concept of using this dispute board after the project is over to resolve all the disputes as an arbitrator so that they don't have to go through the process of picking an arbitrator. That's really demonstrates trust in the three people, the neutrality, the experience, and the demeanor of the three people, the qualifications and character of the three people that were selected for the dispute board. I wanted to just talk about, just for a second, to talk about admissibility and non-admissibility of the dispute board award. And my first exposure of the dispute board process was about 20 years ago. I was sitting as an administrative law judge hearing an arbitration of a construction dispute involving the state of California and a contractor. And one piece of evidence that was submitted was the dispute board opinion. Now, it was advisory and one party objected to it. I'd never heard of dispute boards at that point in time, so I had it explained to me. And then I looked at this opinion, which was very detailed. It was, my recollection, about 20 pages long, went through all the contract terms, the facts, the issues, gave their recommended, because it was an advisory opinion, and the basis for that opinion. And it was very compelling, and it was very helpful, you know, as the ALJ, to help me listen to the parties, why they objected to this advisory opinion, and actually to write my opinion as the arbitrator in that case. That really, there are not very many disputes that go on to the arbitration process, but that just goes to demonstrate how a dispute board, what they do, can be used to help the process all the way to the end of the project. But I think it's a very flexible project, or flexible process. And with the stipulation of both parties, the owner, employer, and the contractor, you know, anything's possible.
Anything you wanted to add to that?
Actually, yeah, I would like to add, I was thinking of your question while Elizabeth was answering it. When a dispute board will make a decision, I can't see how both parties will agree that the same dispute board will be arbitrators, because normally this decision will be in favor of a party and against a party. So one of the parties will want this board to act as arbitrator, and definitely the other party will not, right? Because the decision is against him. So I don't see how both parties may agree that the board will go to will proceed as arbitrators. I think this may happen in very, very rare situations.
Yeah, I think if it's the same dispute, you know, I was looking at listening to the question, if it's the same dispute, they already have, well, a lot of times if it's a 3-member dispute board, the opinion that's written doesn't define if anybody you know, objected to that. It might say that two people on the dispute board wanted it this way, or their recommendation was this way, and the third one was opposed to that. Even if you do have a split decision like that, if it's the same dispute, I can't see, you know, the parties agreeing that you probably can't get the stipulation. But if it's a different dispute and they have trust in the dispute board, they might, you know, if they resolved one dispute with an opinion, and even if a party, it was against them, they still felt that they had trust in the dispute board, they might have them sit as an arbitrator for a final decision on some issue. I don't know. That's my thought.
No, I'm convinced. Yes, you are right. I didn't think that it's another dispute. I was thinking that it's same
But
dispute.
the question was phrased about a dispute escalating. Ideally, the dispute board
Yeah.
has had the first go at it, and they're not looking at something completely afresh. So I think that is a key point. Interestingly, you've talked a little bit about the decision writing process, and that's another question that we received from one of our attendees. So the request was simple, or the question was simple: are there specific guidelines for drafting the decision or recommendation? I know the DRBF recently had a conference back in October where we had a whole workshop dedicated to best practice recommendations for effective decision writing, and the importance of that decision being effective so that it stops there and doesn't escalate to arbitration, right? You want to know, the parties want to have that full understanding of what was considered and what the reasoning is and how that played out in the decision-making process. I imagine it's always going to be a little bit different based on the dispute being reviewed and the particular details, but to the question about guidelines, there probably are some key things that you would want to emphasize for that. So, Dr. Ahmed, would you like to start there on just talking about sort of the key factors that you think are important for an effective decision from the dispute board?
Actually, I believe that when I draft the decision for a dispute adjudication board, it is very similar to an award, an arbitration award. Okay, so it has to be reasoned, it has to include all the facts, it has to include all the contractual basis of my decision, any discussion that has been made with the parties, and so on. So at the end, it has to be operable. This is very important. So parties can use it, and it's just not, you know, like a vague or not easy to execute this decision. So for me, it's almost the same as an arbitration award. I don't know if Elizabeth has a different opinion on that.
Well, I actually agree with you, Ahmed. You know, I want to just put a, I guess, a recommendation for the Chartered Institute of Arbitrators, who I know is sponsoring this event, and their fellow status, because I went through the fellow training and testing here in the United States, actually in Texas, a few years ago. And so that process, and I also want to say that I went through the FIDIG Module 3 training online, which lasted, seems like it was about 6 months long, and involved a lot of writing of DRB, dispute board opinions. So I think it's similar to arbitration and that fellow status. You know, if you've gone through that testing and writing arbitration opinions, it's very similar. And also the FIDIG training and testing and writing opinions is very compelling. I think at the conference, the seminar that we had at the Connections Conference on writing DRB opinions was excellent and really gave a lot of academic information about what you need to put, you know, an outline of what you need to put in your opinion, very similar to what Ahmed is saying. And, but the actual process of doing it, particularly, you know, the actual process can be challenging, particularly when you're writing it with 2 other people. You have 3 people that are participating and editing a document similar to a 3-party arbitration award. So it does take some art and finesse. It takes really understanding what the issues are, the contract terms, you know, all of those things before you sit down to write it. You've got to prepare for the hearing and be ready with an understanding of what the parties are presenting before they do that. So I think, there's a lot of resources, both in arbitration and also dispute board work with the FIDIG training, to learn how to, and to practice, not only to get the academic learning, but also to actually practice writing awards before you're on a dispute board. And of course, each dispute is totally new. It's new contract terms and construction processes and parties, issues. So you have to be on your toes to understand those issues and write something that is really going to make sense and be compelling.
Very good. A new question has come in, which I think flows beautifully from this particular topic, and that is, are there other options if one of the parties does not accept the decision of the board? Are there options other than arbitration and litigation? Now, I have heard about the role of using the decision to continue negotiations between the parties before escalating on. Having the decision in hand gives them some more information that they can then use in direct negotiations. Is that anything either of you have experienced that you'd like to comment on? I see Dr. Ahmed nodding.
Yeah, actually, a few years ago, I was in a dispute board. I was a sole member, and but again, it was an ad hoc dispute board. So at the end of the project, and my decision, the employer was not satisfied. So he issued a notice of dissatisfaction. However, both parties asked me to act as a mediator and to continue the process as a mediator after I issued my decision. And I did that, and they actually reached an amicable settlement through the mediation process, and the case or the dispute did not go to arbitration or litigation. So this was actually a successful, let's call it a dispute board mediation process.
Right. Okay, very good. Well, we are getting near the end of our hour, and we have had several additional questions come in through the chat. So I did just want to summarize by saying that we will attempt to tackle all of these questions that have come in through the chat. Our panelists have agreed to stay on for a few extra moments beyond the 1 hour lot. So you're welcome to stay on. We just wanted to give a few logistical notes. We have been recording. We will be sharing this recording with all of you who attended today and those who registered but could not participate. So if you did need to sign off but want to come back and revisit, I hope you'll find a lot of useful information here that you can apply to your work. Several of the questions that have come in are a little bit of a retread of the same topics that we've been discussing, the escalation and, kind of the role of the dispute board in that overall process with arbitration, litigation, et cetera. So I just want to give a little pitch, as I did at the beginning, about the DRBF manual, because that is something that we do tackle in the book. We show the various stages and the role that the dispute board has in that overall process. And so you can see how they work together and how that flow goes. There's also been a couple of questions about best practice in terms of how you run the operations of a dispute board, fully covered in the manual. And then we've had a couple of other little questions. One was about cost. Someone asked about the cost of a dispute board compared to the overall project costs. Now, the DRBF has asked this question a lot. And of course, there's some variation on the types of projects, the size and scale. Obviously, the larger the project, the smaller the ratio of dispute board to total project costs. But we have tracked projects around the globe for quite a number of years. So when we crunch the numbers, we come between 0.05 and 0.15% of total project costs. Now, we have a chapter in the book that talks about the factors that come into play in the costs of a dispute board. For example, if Elizabeth's driving down the road to a California Department of Transportation project, her travel costs are going to be a lot less than if Dr. Ahmed is getting on a plane and flying to another country and staying in a hotel for the duration of the project. So, you know, there's a lot of factors that can come into play, and we break it down by region and by some of these factors and give you even a little tool that you can use to figure out anticipated costs. So hopefully that covers that comment. Someone just asked about buying the manual. You can buy it. It's available from any online retailer, but we do also make it available as a free download from our website. If you scroll to the top of the chat, you'll see that hyperlink so that you can go to our website and download to your e-reader or computer device and reference that. I will put that link in the email that we send with the link to this recording today as well. So that's also an option for you. So now I'm going to just go back and see if there's some other questions that we have not tackled yet. Now, Dr. Ahmed, I think there was a question about whether DRB is going to be referenced in the local rules. And I believe if I heard you correctly, you said that they are, but maybe you could just comment on that briefly.
Yes, as I said at the beginning of the webinar, that the Cairo Regional Center will be publishing its rules, dispute board rules, by the beginning of 2021. And in these rules, the rules will be covering both the Dispute Adjudication Board and the Dispute Review Board. I know that the Dispute Adjudication Board is, people in Egypt are more familiar with the Dispute Adjudication Board because of the use of FEDIC. But again, due to the benefits that we can get from the DRB, then we included that in the Cairo Regional Center new rules.
Very good. Thank you. There is also a question about if there are dispute boards that are larger than 3 people. That is the gold standard that we talk about, a 3-person board. The question was asked 5, 7. Obviously, there's some benefit to having an uneven number in people's minds. You don't have a split down the middle if you have an uneven number, right? But I do know of some examples of some larger panels, but it's a slightly different model based on the particular project type. So I think the example I often think of is the London Olympics, where there were many projects underway. And so they had a pre-approved panel of people, but then for any specific contract, they would pull from that panel. So any experience with these larger panels? I think, Elizabeth, you mentioned P3 or public-private partnership. I think that might be a contract model that there could be some benefit for different types of dispute boards, right?
Yeah, I actually haven't heard of a P3 project that has, well, as a matter of fact, I have. In the Far East, I heard of a project where they had selected like 9 people to be on a panel, 9 approved people to be on a panel of a dispute board. But for any particular dispute, they would pick 3 people out of that panel. So there was a pre-approved list, again, diversified, you know, if the issue had financial or technical, you know, what was the issue? And for P3 projects, a lot of times there's a technical 3-person panel, there's a financial 3-person panel. So if it's the design build issue, they use the technical, and if it's a issue regarding operations and maintenance, and it's regarding a financial issue, they would use a financial panel. But again, they want a diversified group within each panel. So it's not everybody is an engineer with all the same experience. They want to have people who, you know, engineering, construction, legal. So trying to work that out. I think there's a lot of room for creativity, and defining a flexible process and flexible panel that meet the needs of each project. As our projects get bigger throughout the world, as contractors, design professionals are crossing borders to provide services and labor and materials, we have a more complex situation, more complex countries, culture, etc. So I think always, continuing with exploring how the flexibility of this process can meet the needs of the particular project and the parties involved is important.
Very good. Dr. Ahmed, there's been a couple of questions that have a recurring theme of maybe distinguishing between projects that have all domestic parties versus international, maybe a domestic employer and an international contractor or something along those lines. So can you comment, do you see anything that is particularly different in your area about having all domestic parties versus the multinational experience?
Yeah, actually, in projects, as I told you before, that if both parties are domestic or are local parties, then the employer will normally omit the dispute board clauses from the contract. Employers are in projects that are funded by multilateral development banks, such as the World Bank, for example, and we have many projects like this in Egypt. The government, or who's the employer in this case, has to use the form, the FIDIC form, the pink book, or whatever required by the World Bank. And in this case, they have the dispute board there. So, and from my experience, these are the project where most of the dispute boards in Egypt are formed. The projects that are funded by a multilateral development bank. So, just to go back and answer the questions, it doesn't matter if we have domestic parties or international parties. It matters if we have a funding agency who is requiring the employer to use a contract with a dispute board. But I was involved in contracts with both parties were domestic, and the project was not funded by any agency, and they selected to include the dispute board. So it happened even when we have domestic parties.
Okay, very good. We have an interesting question about how the DRB might operate in a scenario where the contract doesn't cover a particular topic. So the example given was if it's not mentioned about invoice review durations or payment procedures, how can the DRB address issues that are not in the contract? Elizabeth, can you comment on that?
Seems to me that those types of issues would be brought up at the regular dispute board meetings, and that the construction administration and processes is something that the dispute board can bring up as a topic, and the parties can contribute and reach a resolution quite quickly on those kinds of issues. So that is perfect for the dispute avoidance process. If those kinds of issues are not addressed and resolved in the regular dispute board meetings with the parties, then they can fester and become, kind of a breeding ground for other problems on the project, or lead to other problems on the project. So to me, that would be something that would be addressed at a regular meeting. You could ask, if you need it seems like discussion with the parties would resolve that. But if you need an opinion, there could be an informal advisory opinion by the dispute board to assist in the parties in reaching a resolution on those kinds of issues.
I've recently heard it referred to as the art of the dispute board. You know, the ability to be able to ask the right questions and guide. It's all that nuance that comes out in the dispute avoidance role of the dispute board that I think is really a primary thing that arbitrators need to understand about the process. I've noticed a lot of questions in our Q&A are talking about the dispute board acting as an arbitrator. And so I think we need to clear that up a little bit because the dispute board process is not an arbitration process. Although often we have dispute board members who do all forms of ADR. They serve as mediators, they serve as arbitrators, they serve as adjudicators, expert witness, and dispute board members. So maybe if you could just give a little bit of clarity to that for the audience. Dr. Ahmed, can you comment on that from your perspective?
Yes, actually, again, the problem is with the ad hoc dispute boards. Ad hoc dispute boards, you are not getting the benefit of this. Dispute boards are definitely not, it's totally different than an arbitration process. In arbitration, you are not giving a recommendation, you are not giving opinion, you are not trying to avoid the dispute. Okay, and these are the main benefits of a dispute board. The dispute board is there from the beginning of the project. The dispute board is there to understand the project while it is being executed. So understanding the problems as they arise, trying to avoid the problems. Even when a dispute is referred to a dispute board, the members are already well acquainted with all the issues, are monitoring the progress of the work. They don't have to take a lot of time to understand the documents and to understand the dispute. So this is also very important. They can meet with the parties to give them opinions. They can before even a dispute arises, the board, if they believe that there is a potential of a dispute, they can call the parties and try to avoid the dispute before it arises. So all these are elements that are totally different than the arbitration process. Arbitration is more of a formal litigation-like process where the dispute is being referred to, and the arbitrators will make will issue a final and binding award. So it is much more formal, and you are not getting the benefit of the avoidance and the opinions and so on.
Exactly. Very good. Thank you. We are coming, I think, to the end of our session today. And I want to thank you both very much for dedicating your time to talk about this topic. And as a reminder, we do have the recording that will be available for everyone. And I'll include a few links to some of the resources that people have asked about today in the email that comes to you at the beginning of the week so that you'll have those easy to access. Before we wrap up, I just will open up the floor to the two of you, Elizabeth and Dr. Ahmed. Are there any final messages or points that you'd like to share with our audience today? Elizabeth?
Well, I look forward to meeting, first of all, Ahmed, thank you. I look forward to meeting you in person, even though it's been great being on this panel with you. And the other people that are on listening to this webinar, I hope that you'll all join the Dispute Board Foundation and that we will have an opportunity to meet face-to-face, maybe at the international conference or maybe an event in Cairo, Egypt even. I don't know where everybody is from, but I look forward to meeting you all in the future. And please let me know that you were actually in this webinar and listened to it. So anyway, thank you, Anne. Great opportunity here to this Saturday morning travel from San Francisco to Cairo, Egypt, and appreciate the opportunity today. Thank you.
Very good. Thank you. Dr. Ahmed?
Yeah, thank you, Anne, so much for moderating for being a great moderator. And thank you so much, Elizabeth, for it was really a pleasure to participate in this webinar with you. And I'm looking forward to meeting you both in Cairo. As we said, next time you'll be in Cairo. And I would like also to thank all participants for their valuable questions. And we hope that we were able in this 1 hour to answer as much questions as we could. And I'm looking forward for a future collaboration with the Dispute Resolution Board Foundation. And finally, just for people in Egypt, just stay tuned for the new rules that will be published by the Cairo Regional Center in next month, inshallah.
Very good. We have something interesting to look forward to in the new year. So thank you. I do hope that we continue the dialogue, keep the conversation going, and that we see many of you again, either online or in person at a future event. Thank you again for participating. Bye-bye.
Thank you.